The other most important objective that laid down in the preamble of our Constitution is liberty, and that liberty of thought, liberty of expression, belief, faith, and worship, and as it is provided under the different parts and exactly in part 3 of the Constitution, which we found under Article 19, which relates to right to freedom, and those rights to freedom consist almost six freedoms, but before the removal or deletion of the sixth freedom from Article 19, and that was Article 19, Clause F, which was dealing with the right or freedom to hold and acquire and dispose properties under 44th Constitutional Amendment Act of 1978, and all the rest freedoms as existing at present are the freedom of speech and expression, the freedom to assemble, the freedom to move anywhere in India, to freedom to settle anywhere in India, and freedom to form association unions, and freedom to carry out any occupation, trade, commerce, business, etc. So these are the freedoms as provided under Article 19 clearly explain the very concept of liberty. And as we'll go to the other fundamental right, that is regarding double jeopardy, and that is provided under Article 20, which clearly defines that no one can be punished or convicted for the same offense twice. And if we'll go to the most important article, that is Article 21, which deals with right to life and personal liberty, and in that context, we found many such basic fundamental rights that which include such as right to livelihood, right to health, right to medical facilities, right to speedy trial, the very right relating to privacy, etc., which you would like to discuss when you will discuss in detail the very provision of right to life and personal liberty as provided under Article 21. And while discussing the very right to freedom as under Article 19, there we found certain reasonable restrictions regarding those freedoms. So, these particular freedoms relating to reasonable restriction explain about the positive concept of liberty. As already we know that liberty has two aspects. One is negative concept of liberty, and the second one is positive concept of liberty. So reasonable restriction on these freedoms are otherwise called the positive concept of liberty. So also under Article 22 we found the very provision regarding protection against arrest and detention, and in that regard The state has already enacted many legislations such as the Preventive Detention Act of 1950 and the Maintenance of Internal Security Act in 1971, the National Security Act in 1980, and many such acts were enacted by the state, but there is certain limitations on the state action relating to arrest and detention, and that protection is provided that before any such detention and arrest, the state must consult with an advisory board which consists the judges of the High Court, and so also another important right that relates to liberty is right to freedom of religion, as we found under Article 25 to 28, that provides all people in India the very right to profess and propagate and the freedom of belief, faith, and worship, and that constitutes the right to freedom of religion as provided under Article 25 to 28 of the Constitution. Besides that, Article 29 and 30 of the Constitution, which are also fundamental rights, it provides regarding cultural and educational rights of minorities. So the minorities communities in India, such as the Muslims, Christians, the Parsis, the Jews, they could establish and run their own cultural and educational institution without any state interference. And so also we would like to discuss those constitutional remedies provided under Article 32 in regards to the Supreme Court or the Apex Court of India, and also Article 226 regarding the high courts in different states, and those constitutional remedies under Article 32 are in five numbers such as habeas corpus, quo warranto, certiorari, prohibition, and mandamus. So these constitutional remedies are definitely the guaranteed protection provided to all Indians for violation or infringement of any of the fundamental rights provided in Part 3 of the Constitution. Anyone can go for judicial review of the very actions of the legislature or the executive or any administrative actions which violates and infringe the very fundamental rights of the individuals or citizens of India as provided under Article 32, which itself is a fundamental rights. So also another concept that relates to liberty is the free legal aid as it is provided under Article 39A, which was inserted under the 42nd Constitutional Amendment of 1976. So, this very provision of free legal aid is provided to all those downtrodden, illiterate, ignorant, and poverty stricken people or the backward classes, even to those women and children, those who have no opportunity to represent or to engage a counsel or an advocate in the court of law for enforcement of their rights. So this is another part of the very idea of liberty as portrayed in the preamble of the Constitution. So also another provision that is regarding free and compulsory education for children, those who are below 14 years of age, is also a part of liberty as it is provided under Article 21A, and that is being inserted under the 86th Amendment of the Constitution in 2002. So, these are the very concepts as we found in the constitutional provisions relates to the very ideal of liberty as portrayed in our preamble. And in relation to that, we would like to discuss very important leading case, that is Selvi versus State of Karnataka in 2010. The Supreme Court expressed that the task of legislature to arrive at a pragmatic balance between the competing interests of personal liberty and public safety, and also will discuss some other important leading cases relating to the very ideal and concept of liberty as portrayed in our preamble. So these are the state of Karnataka versus Associate Management of English Medium School 2014. The Supreme Court declared, and also another leading case that also relating to the same decision is Avik Sarkar versus State of West Bengal in 2014. That was also decided by the Supreme Court in relation to the very ideal of liberty. So also another important case of 2015 is Devi Das Ramchandra versus State of Maharashtra. And 2015, the Supreme Court in all the above three important leading cases defined the very word and ideal of liberty as it is enshrined in the preamble and also in part 3 of the Constitution under Article 19. So, as per the observation of the apex court, the words liberty of thoughts and expression as provided under Article 19 Clause 1 Subclause A is linked with the objectives of the preamble, forms a part of the basic structure of the Constitution. So, while interpreting it, it is the duty of the court to realize the value of the Constitution. So, this is the analysis and expression of the very ideal of liberty as it is portrayed in our preamble by our founding fathers of the Constitution of India.